Welcome to our program today, Face the Music, Takeaways from the Live Nation Ticketmaster Antitrust Case. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Taylor Owings. Ms. Owings is a partner in the New York office of Wilson Sonsini, where she represents clients in civil merger and non-merger antitrust matters before federal and state agencies and in private litigation, with a particular focus on technology-driven industries. Prior to joining the firm, she served in the U.S. Department of Justice's Antitrust Division, rising to the Chief of Staff, where she was a key advisor on antitrust issues involving market-leading online platforms and was the recipient of both the Assistant Attorney General's Award and the Attorney General's Award for Distinguished Service. A widely recognized practitioner, Ms. Owings was named to Bloomberg Law's 2025 40 Under 40, honored as a 2025 Rising Star by the New York Legal Awards, and recognized in the New York Antitrust category in the 2025 edition of Chambers USA. We're so excited to hear what she has to share with us today, so I'm going to turn it over to her.
Thanks so much. And thanks so much to the Beverly Hills Bar Association for having me. I'm a California native, although I practice today in New York. So it's really fun to be with you and get a little use out of my California bar license, which I don't have as much occasion to do nowadays. What I want to do today, we have a very short amount of time together. So I really want to give you the greatest hits from the Live Nation Ticketmaster trial, give you a sense of where that matter has been, where it's going, and what it means for you, your practice, and for your clients. I would like, before we begin, to just encourage you to use the Q&A function that's in your screen. I'd love it to be a dialogue if you guys have questions while I'm going through the presentation. So please let me know what's most interesting to you, how this is impactful for you and your clients, and we can be in that dialogue. So let's kick it off by starting with a sort of brief chronology of the Live Nation Ticketmaster matter and where it's headed from here. So in 2009, Live Nation acquired Ticketmaster. Live Nation previously had been just an events management company and owner of venues. So it was a concert promoter, a live events promoter that also owned venues. And when it acquired Ticketmaster, that merger was investigated by the Department of Justice pursuant to its regular powers to look at large mergers, decide whether there are going to be any competitive issues with them, and potentially sue to block those transactions that have competitive issues. So in 2009, when that merger was being investigated, the Department of Justice decided to resolve any of its concerns by entering a consent decree with Live Nation and Ticketmaster. So in 2010, the DOJ brought a complaint, it brought a challenge against the merger, articulating the ways in which it could be anti-competitive and harm consumers in the market for ticketing and concert promotion services. And it articulated a remedy that was going to prevent that harm from happening. The nature of that remedy was that Ticketmaster and Live Nation would not be able to use Live Nation's control over concerts to force venues to accept its ticketing services. So you couldn't use the existing power that Live Nation had over concerts to force venues to accept the ticketing services that were now being acquired and sort of bolted on to that existing concert promotion business. So the consent decree was entered in 2010, and according to the DOJ's telling, there were almost immediately compliance issues. And we know this because fast forward to 2018, And this is while I was working at the Department of Justice. In 2018, the DOJ filed in that same court where the complaint was resolved by consent decree. It filed a motion to extend and modify the consent decree on the basis that Live Nation had been violating it. And in that motion, you saw a litany of examples of how Live Nation had been using its control over concert promotion services to force venues to take Ticketmaster ticketing services. And those examples in the DOJ motion were all the way from 2011 to 2018. And so really the consent decree that had been entered into in the Obama administration had been well-intended and had the right measures in it, but it had not really been successful. Accordingly, in 2018, the court overseeing that consent decree agreed with a modification request. The parties extended that consent decree and got a little bit more specific about the tactics that Live Nation wouldn't be able to use in conditioning and threatening venues to take Ticketmaster ticketing services. So what happened next? In May 2022, the next administration, the Biden administration, filed a lawsuit here in New York. The lawsuit is an interesting example of a situation where the DOJ has already resolved certain concerns, specifically the concern over the actual merging of Live Nation and Ticketmaster. It's resolved those concerns in a consent decree. So the complaint filed in 2022 needed to articulate different legal theories. And so that's what you see. Very careful pleading in the lawsuit filed in 2022. It's the allegations of anti-competitive conduct are not that Live Nation acquired Ticketmaster, and it's careful even to describe the types of conduct that was illegal as not being in the same terms as the violations of the consent decree. So how did they get around this? It was largely by bringing in a new market and alleging a monopoly over it. That new market was amphitheaters. So by looking at a specific market for venues that hadn't been involved in the merger, in the original merger, in which the Live Nation had acquired more venues in the interim, DOJ was able to make out a complaint that was really distinct from the prior proceedings about the combination of Live Nation and Ticketmaster. So they alleged that Ticketmaster was unfairly forcing venues to take its ticketing service by virtue of having control over amphitheaters. Having control over amphitheaters meant that it could have control over artist promotion services because those artists needed to have access to the amphitheaters. And then in turn, because they had control over a high percentage of promotional services and artists, they were able to force venues to take ticketing services, leading to that illegal monopoly in ticketing services. So this lawsuit was brought by DOJ and a remarkable bipartisan coalition. Nearly every state AG joined the lawsuit. And in April 2026, the trial started here in New York. After 3 days of argument in the trial, DOJ settled out suddenly from the complaint, and it filed a notice with the court that, by all accounts, was surprising even to the DOJ lawyers working on the trial. So we know from those reports and from the ensuing consent decree that was filed on the record, that this high-level deal was struck. And we'll talk a little bit about what that consent decree says and what it requires of Live Nation. Now, with the litigants surprised by DOJ's settling out of the trial, there was a question, what happens next? And some state AGs decided to join DOJ's settlement and accept the commitments that Live Nation had entered into as sufficient to resolve competitive concerns. But the vast majority of states were not happy with the settlement terms, did not feel it was sufficient to resolve competitive concerns, and decided to keep going with the trial. They hurriedly found new lead trial counsel and resumed the trial in front of again, by all accounts, grumpy judge who felt that this was jeopardizing the flow of the trial and the jurors' time and efforts thus far. Nevertheless, they picked up and kept going with the presentation of trial evidence, and indeed, at the conclusion of the presentation of evidence, the states who continued on in the trial won a jury verdict indicating that indeed Live Nation had monopolized various markets that we will talk about, and articulated that ticket prices had been overcharged by on the order of magnitude of about $2 a ticket as a result of that monopoly power illegally obtained. So where are we now? We are currently in the post-trial phase, and three things are happening right now. First, DOJ and the states who joined DOJ in the settlement agreement have filed their settlement with the court, and that settlement agreement needs to go through the statutory approval process, which is specific to antitrust consent decrees. That's called the Tunney Act proceeding. And under the Tunney Act, the judge will have to certify that the remedy that DOJ is entering into serves the public interest. Second, Live Nation has moved for a judgment as a matter of law and for a new trial. So they've raised various issues with the evidence that have gone in, that went in at trial, and they are taking the position that they are due a judgment as a matter of law. And short of that, a new trial that would limit the evidence to more recent evidence and trying to strike other evidence they characterize as prejudicial and beside the point. And then finally, the states who won their verdict have filed a proposal to the court for how to proceed to a remedies phase of the trial. So though the jury found liability and articulated the amount of damages, there's still a question about how to resolve the current situation and restore competition to the market. The states have filed a letter with the court indicating the remedies that might be appropriate here, and therefore the remedies on which they need discovery. And so we would enter a phase now where the parties would undertake discovery on the effect of the potential remedies that the states are seeking, and try to prove what remedies are necessary over and above the remedies that DOJ secured in its consent decree. So that's an overview of what has happened so far. And the question I think that's most interesting to discuss here today is what should you take away? What lessons can be learned? And specifically, what is it about this trial that has so captivated people? And I think that one theme that I want to start with is a reminder for antitrust practitioners, but also very really across the board, antitrust watchers. It's important to remember that in antitrust law, big isn't bad. Big is not being big, having a monopoly is not illegal. This is a common misconception. And when you read popular press reports reporting on antitrust trials, And the reporting can often be imprecise, and it can give the sense that evidence as it comes in that Live Nation or Ticketmaster has pricing power or is a monopolist, that's sufficient for the government to win its antitrust claims. But it's not. Big isn't bad. But what big is bad for a jury trial. And I think that is a takeaway that we are seeing again and again right now across the antitrust landscape. So as a reminder, building a better mousetrap and obtaining a monopoly through building a better mousetrap isn't illegal. And that was Live Nation Ticketmaster's trial theme for sure. They knew they weren't going to be able to get around some of the evidence showing that they really did have power in certain markets, that they were able to charge higher prices or able to pressure certain parties in the entertainment ecosystem. That evidence was coming in one way or the other, but what they had to argue was, we have that power because we're a better mousetrap, because when we vertically integrated, we're solving pain points for people, we have a better mousetrap, and therefore that's why we're big, and that's why we have the ability to charge higher prices, etc. Unfortunately for Live Nation and Ticketmaster, whenever you do have monopoly power, regardless of whether it came from building a better mousetrap or not, the reality is that you are able to do things that upset customers, and that makes for a really bad trial experience. And we saw tons of reporting throughout the media press and throughout the traditional press that really highlighted some of these painful moments in the Live Nation and Ticketmaster history. We saw these sort of bombastic quotes about how employees were bragging that they could rob customers blind, or denigrating their customers about how I almost feel bad for taking advantage of them, was one of the quotes coming in from a salesperson in the company. Other comments around, I gouged them on ancillary prices to make up for the lack of control over the artist pricing. So these quotes that came in were able to be used by great effect by the government. And it really created I think, an uphill battle in the court of public perception as well. Even worse, when you are a monopoly, when you do have high market shares, again, regardless whether you got that through building a better mousetrap or not, you're able to do things that, in this case, upset famous artists. That's also an uphill battle, right? So I think most pointedly, it will escape no one's memory that Taylor Swift took a stand against Ticketmaster, sort of immediately preceding DOJ and all the state AGs filing suit. In April 2022, she publicized her displeasure with the way Ticketmaster had handled her Eras tour ticketing, and a month later, in May 2022, the lawsuit was filed. Similarly, as evidence came in at trial, Billie Eilish was brought to bear. Billie Eilish's team claimed that they had been pressured to move their concert away from the Barclays Center, where it had originally been scheduled to appear before COVID. And this sort of this sense of somebody as popular and with as much sort of public power as Billie Eilish or Taylor Swift being on the receiving end of monopoly power from Ticketmaster, that is something that was a really big uphill battle for Ticketmaster in the presentation of evidence. So another thing to keep in mind here is that even we talked about big isn't necessarily bad, but it's bad for trial presentation. I think things were made especially difficult for Ticketmaster here, not only because they are big, not only because the people on the receiving ends of their power are famous artists and those with sympathetic followings, but also they are the face to the customer of an industry that is actually really based on monopoly. The whole idea of live events and intellectual property as owned by artists is that it's scarce. There's only one Billie Eilish. There's only one Taylor Swift, and as many concert dates as she can put on, it's still scarce, and there's still sort of monopoly power over trying to go see Taylor Swift. As a result, Ticketmaster is really in the position of passing along a lot of monopoly prices, a lot of monopoly sort of effects that customers are not happy about, right? People are not happy that output for Taylor Swift is entire. There's way more demand than there is supply. That's a classic monopolistic outcome. And nevertheless, is that piece of it really Ticketmaster's fault? No, but they're the website, they're the interface for those monopoly prices and those, again, fairly held monopolies, but it's an uphill battle in terms of the presentation of evidence and the number of sort of unfortunate pieces of evidence and scenarios and exchanges that happened within the company are really downstream of that unique fact about the media industry. So if big isn't bad, then what is, right? This is a question of what can Ticketmaster and Live Nation actually be held liable for. And to be honest, it's one of the hardest questions in antitrust law. What conduct is it that a monopolist cannot do? What makes this really, really hard is that the same business practices that are perfectly legal when a company with small market share does them become illegal once that company has large market share and monopoly power. So if you're building a better mousetrap, if you're furiously building a better mousetrap, gaining market share, suddenly some tactics that you could do perfectly legally before are no longer legal once you pass that threshold of monopoly power. So in this case, those practices were exclusive contracts. So the evidence came in that Ticketmaster was making no room for artists to sell tickets to their fan clubs, that if you were going to take Ticketmaster services, that every single one of your tickets had to be through Ticketmaster. Similarly, exclusive contracts with venues that were long lasting. So if a venue wanted to take Ticketmaster services now, the evidence came in that Ticketmaster was requiring them to take those services for a long period of time. And so these extensions of monopoly via exclusive contracts, those are perfectly legal when it's not a monopolist doing them, but illegal and an antitrust violation when it's a monopolist doing them. And then similarly, kind of at the heart of the complaint, tying is the antitrust conduct that becomes illegal when you have market power. So when Ticketmaster forces you to take ticketing services if you want access to its artists, or if it forces you to take its promotion services because you want access to its venues, its amphitheaters, that becomes illegal when you have power in each of those constituent markets. So if you have monopoly power, if you have large market share in venues, you can't use that to get large market share, get monopoly power in promotional services. And then likewise, once you have that promotional service monopoly, you can't use that power in promotional services to get a monopoly in ticketing services. So it's this interrelationship that becomes illegal only when you have that high market share and that monopoly power. So again, this makes for a terrible time during trial, because the evidence that has to come in is all about how people are suffering really under Live Nation and Ticketmaster's tactics, how they're feeling pressured. And it's all very sympathetic evidence for a jury to hear. It's something that everybody can relate to, who feels like they have no options when they're in the media landscape and trying to get a ticket to their favorite artist. So another thing that makes this complicated is the fact that it's actually hard to know when you have a monopoly. And a significant amount of the evidence at trial was trying to answer the question, does Ticketmaster really have a monopoly? So market shares are an indication of monopoly power. But in order to even calculate market shares, you have to be able to define the market. So you have to, a share of what is the question. And so when you try to define the market precisely, there's lots of quibbling over whether that's the correct market and whether there's actually substitutability around the edges of that market. So, for instance, in this case, there was a question whether amphitheaters are actually their own market. Do artists really only look to amphitheaters when they're looking for where to stage their concerts, or do amphitheaters compete with nearby sort of regular concert venues? If you limit the market to just amphitheaters, then Live Nation had a 60% plus market share, and got sort of a presumption of monopoly power. But if you included substitutes, then you wouldn't be able to prove that monopoly power through market share. Similarly, Ticketmaster took issue with the definition of ticketing for major concert events. They said ticketing services are actually fungible. And somebody who's providing ticketing services for sporting events could easily provide ticketing services for concert events. And so there was, again, a question about how you define the market there. The fact that the trial was fought on these grounds is really indicative, again, of how much Live Nation and Ticketmaster needed to be in the weeds trying to fight on these sort of theoretical or academic grounds, whereas the states and the government could just present evidence generally of the effects of the power that people, consumers, venues, and artists were feeling in dealing with Live Nation, Ticketmaster. Again, much more sort of gut level, attractive sort of trial testimony than the sort of academic quibbling that Live Nation and Ticketmaster needed to do. So I know we only have 2 minutes left, and I want to make sure that we're thinking about what's most useful for your clients and what you want to take away from this as you watch the events unfold next. So I think I'll just quickly highlight for you what's definitely going to change, because DOJ has already secured in its settlement. In its settlement, the DOJ has secured a commitment from Live Nation and Ticketmaster that it will no longer enter any exclusive agreements for longer than 4 years. It's gotten a commitment that even if an artist doesn't use Live Nation, they should be allowed to use Live Nation venues, and they should be getting the same pricing that they would be getting if they were using its promoter services. They've also secured a promise of a cap on Ticketmaster's fees at 15%. And they've also secured a requirement that Live Nation divest control of 13 concert venues that were especially important to its ability to pressure artists to take promotion services. So that's the bucket of remedies that's definitely going to happen. What is still on the table is what are the state's going to get. Of course, their verdict needs to withstand the post-trial briefing, motions practice, and I'm sure an eventual appeal. But it's worth noting that the states have announced both publicly and in their letter to the court that they are seeking a breakup, that they think that the only remedy that will work is as Live Nation and Ticketmaster no longer being joined at the hip, so that this forcing mechanism, the forcing between the two companies, can no longer happen. This is something that DOJ again was a little hard pressed to potentially go for, because it had approved the merger back in 2010. So in some sense, even though I think there's a lot of controversy around DOJ settling out of this case, there's a way in which it's kind of cleaner for the states to be the ones trying to get this remedy of a breakup. And it will certainly be an interesting procedural question to watch, whether the states can put in evidence, get discovery and put in evidence that the breakup is necessary, especially given that we have this intervening step of the DOJ having a consent decree in place that arguably is going to be effective in remediating the competitive effects of Live Nation's conduct. So the question will be, can the states prove that no, DOJ's remedy is not enough, and in fact you need additional relief on top of DOJ's remedy in order to put us back into a situation of competitive, of a fair competitive playing field. So a couple of quick takeaways for our antitrust practitioners out there. I think the things that I really learned from this experience, from watching this and from observing this super interesting trial, is that California in particular is on independent footing as an antitrust enforcer. It's prepared from this situation to be able to go to trial on its own. It's increased its budget. It's recently gotten approval from the state to do a lot more hiring into its antitrust section. And it's increasingly going to be capable and prepared to be an enforcer on its own 2 feet, not just a tag-along enforcer with the federal DOJ or FTC. Another observation is that DOJ continues to prove to us that it's really more interested in accepting settlements and trying to move on with getting to other matters and handling more matters, rather than dragging out matters, including merger reviews or monopolization cases when there's a settlement on a table. So a practitioner's tip is to really be looking out for places where you can negotiate with the DOJ to achieve your goals through a settlement. And then for the trial attorneys out there, it's been a boon recently for monopolization jury trials. We've seen a couple of instances of juries really responding to the type of evidence that comes in monopolization trials, and we've actually seen, even though you think of the right to jury trial as being something that's in the Constitution to protect the rights of defendants, the defendants need to be able to be tried by a jury of their peers. That's the constitutional value at issue. Nevertheless, you actually see defendants shying away from jury trials and the government being the one seeking jury trials in the antitrust context, because of the way this evidentiary issues are playing out. And then finally, I would just remind everyone, a vertical business model is not itself illegal, and being a monopoly is not itself illegal. It's when you have a combination of the two that you're going to start having antitrust issues. So if you work with clients who have ticketing services that are tied to their venue ownership, that's not necessarily illegal just because of this holding. It's only when you get into the world of either of those services being above 50% market share where you want to start being concerned, being very careful in the conduct, the way that you interact with artists and other folks in the entertainment ecosystem. So please reach out if you do find yourself in that situation, or if you're considering a merger that would bring you up to 50% in one of these areas and have questions about whether your conduct suddenly becomes illegal if you have high market shares. For instance, if you were to acquire the second of 4 venues in a particular locale. That's what we're here for as your antitrust attorneys, and I'd be happy to talk to anyone after the presentation, or please email me, Taylor Owings at Wilson Sonsini. My email is on the website.
This concludes today's presentation. Thank you so much, Taylor, for an excellent presentation today, and thank you so much to our audience for joining us. Have a great day, everybody.